Good morning, friends. Today I am going to talk about the constitutional and statutory validity of entry number 453 of Schedule 3 to the rate notification issued under the IGST Act, CGST Act, and the State GST Act. As you know, that the GST has adopted the HSN. Good morning, friends. Today I am going to talk about the entry validity So, let me restart that what I'm going to discuss today is the validity of the residuary entry, that is the entry number 453 in the Schedule 3 to the rate notification issued under the GST law. Now, you might be wondering as to why I want to discuss about this particular entry and what is the significance of this. Significance, according to me, is this, that this residual entry contains about 89% of the item which are not notified till date about the rate applicable to them. Schedule, when the notification was issued on 28th of June 2017, with respect to the rate applicable to the various items, then at that point of time, Schedule 1 contained, there were 6 schedules which contained the rate of central tax to be 5%, 12%, 18%, 28%, and also 3% and 0.25%. Most of the goods are covered under Schedule number 1 to 4, because Schedule 5 contains only 18 entries and Schedule 6 consists of 3 entries. So let us ignore the Schedule 5 and Schedule 6. But Schedule 1 contains 240 entries. Schedule 3 contains 453 entries. Schedule 1 is applicable, the rate of tax applicable is 5%. Schedule 2, which contains 242 entries, has a rate of 12%. Schedule 3, which contains the maximum entries or the maximum items which have been listed, contains 453 entries and it is taxable at the rate of 18%. Schedule 4 consists of 228 entries. And Schedule 4 has a taxable rate of 28%. Now, entry number, serial number 453 of the Schedule 3, which attracts 18% rate of tax, states that it is a residual entry and it covered goods falling under any chapter, but which is not specifically mentioned in Schedule 1, 2, 4, 5, and 6. So if an item is not mentioned in Schedule 1, 2, 4, 5, and 6, then it will fall in residual category. So it does not contain items which is already there in Schedule 3. Only if any item does not contain in Schedule 1, 2, 4, 5, and 6, then only it goes to the residual entry. If an item is already there in the Schedule 3, that is the item which attracts 18% of the rate, it is not there in Schedule 3. Now, the reason I am discussing this particular entry is that the GST has adopted the Customs Tariff Act. It says that heading, subheading, chapter, as it is specified in such first schedule to the Customs Tariff Act, will apply to this rate notification also. So, tariff item, subheading, heading, and chapter, as they are stated in the Customs Tariff Act, has been adopted for the rate notification or for the purpose of classification in the GST also. Now, if we go to the Customs Tariff Act, we'll find that there are 98 chapters and there are about 11,000 items which are there in the Customs Tariff Act. Whereas if you look at if you look at the number of items which have been notified by virtue of the rate notification issued under GST, then only about 1,200 odd items have been notified. So you might wonder as to how this about 9,800 items will be classified. I'm going to talk about that as to how 9,800 items will be classified on the basis of this 12 urban entries. But the main purpose of today's discussion is whether this residual entry, which states that if an item is not notified in either Schedule 1, Schedule 2, Schedule 4, Schedule 5, or Schedule 6 of the rate notification, then it will go to the residual entry. Now, in order to understand the constitutional and statutory validity of this particular entry, let us have a look at Article 279, capital A of the Constitution of India, which states that the GST Council shall make recommendation to the Union and states on wide range of subjects relating to GST. Now, Article 279, capital A, paragraph 4 and subparagraph E says that the GST Council shall make recommendation to the Union and the states on the rate, including the floor rate with band of goods and service tax. So the GST Council has been empowered to recommend to the Union and the states the rate of tax of the goods. Now, simultaneously, the GST Act, Section 9 says that the central government will notify the rate of tax on supply of goods on recommendation of the GST Council. So, Section 9 says that the rate of tax can only be notified if it has been recommended by the GST Council. So, without there being any recommendation of the GST Council, rate of tax cannot be notified either by the center or the state on their own. Now, in this context, a 3-judges bench of Honorable Supreme Court in the case of Union of India versus Mohit Mineral also stated that the certain provisions of the IGST, CGST, and SGST Act expressly provides that the rule-making power delegated to the government shall be exercised on recommendation of the GST Council. For example, the taxable event, taxable rate, and the taxable value shall be notified by the government on the recommendation of the council. Similarly, the power of the central government to exempt goods or services shall also be exercised on recommendation of the GST council. So all power relating to the taxability, the rate of tax, as well as the power to exempt can only be exercised on recommendation of the GST council and not otherwise. So therefore, it is very clear that it is only the GST council which, if approves and recommends to the government to specify a rate with respect to a particular item, only then it has a validity in the eye of law and not otherwise. So the central government or the state government on its own cannot either issue the rate notification or amend it without there being any corresponding recommendation from the GST council. Now let us have a look at how the GST council approved the rate of tax and how they finalized, how the process was done to approve the rate of tax with respect to various items. Now, the process to finalize the rate of tax started with the third GST council meeting, which was held on 18th of October and 19th of October 2016, wherein it was decided to subsume various central and state taxes under the GST. For example, central taxes which were subsumed were central excise, service tax, countervailing duty, special additional duty, and cesses and surcharge as they related to the supply of goods services, the taxes which were subsumed. And with respect to the state taxes, VAT, CST, entertainment tax, luxury tax, entry tax, advertisement tax, these taxes and states cess and surcharges applicable to these taxes were also subsumed. Now, in the third GST council, broad parameters with respect to the slab of rates were decided. There was no item-wise discussion in the third GST council meeting. The endeavor was to find out the rate of taxes, the band of rate of tax, or the slabs of the rate of tax. So in the third GST council, it was decided that there will be 4 slabs, that is 6%. It was decided if the combined rate of central excise and VAT is between 3 to 9%, then it will go to the 6% slab. If the combined rate of central excise and VAT is 9 to 15%, then it will go to 12% slab. If the combined rate is 15 to 21, then it will go to 18% slab. And if the combined tax rate is equal to or more than 21%, then it will go to 26% slab. And it was the basic principle which was adopted to work out the rate of tax or the proposed rate slab. So there were some basic principles which were adopted to decide the rate of tax. And these included that the proposed rate slab should be closest to the present combined tax incidence of excise and VAT, protecting the existing revenue of the center and states, impact on inflation. Proposed GST rate should not be regressive, and the item of mass consumption should not be taxed at a higher rate. Now, in this backdrop, 4th GST meeting was held on 3rd November 2016 and 4th November, wherein the proposed band rate or the slabs were again discussed, and it was decided that instead of 6% slab, the lowest band rate of tax will be 5%. The standard tax rate will be 12%, 18%, and there will be a higher band rate of 28%. And in the fourth GST Council meeting, it was decided that on the broad parameters which have been decided, a fitment committee, a committee of officers of the central and state government, which was known as fitment committee, shall carry out the exercise of fitment of goods and services in the various slab rates, namely the exempted category, the 5% rate, 12% rate, 18% rate, and the highest rate of 28%. And the committee shall take into account all the factors which were discussed in the third meeting. And it was decided that the committee will bring out the outcome of their exercise before the GST Council for further decision. So it is only the GST Council which could decide the rate of tax. Fitment committee had no power to decide on their own the rate of tax. They were supposed to fit the various items, commodities, and services within the slab or the band of rate of tax which was decided. And then give their recommendation to the GST Council for their forthcoming meeting. So the fitment committee met several times, 6 times to be precise, on 18th and 19th of April 2017, 4th and 6th of May 2017, and 10th of May to fit the goods in the band of rate of GST approved by the GST Council on the basis of guidelines which were given by the Council. So GST Council put together a 5 proposed band rates, that is 5, 12, 18, 28, and nil, obviously. And these annexures were circulated by the fitment committee by way of agenda notes of the 14th GST Council meeting to be held on 18th and 19th May. So this 14th GST Council is the most crucial meeting which was held to decide the various rates of tax with respect to various goods and services. Now, in order to know as to how these recommendations were made, it would be very important for you to look into the agenda of this 14th GST Council meeting. I'll just show you as to how this agenda was circulated and what it looked like. So I'm sharing with you the screen of the agenda note number 9 of the 14th GST Council meeting, which is the most crucial meeting to decide the rate of tax applicable to the various items. It decided that there will be 5%, lowest band rate of 5%, standard rate of 12 and 18%, and higher band rate of 28%. And it was also decided that supply of services shall be generally taxed at the rate of 18%. So as you can see, that there were 5 annexure. Annexure 1, which indicated nil rate of tax. Annexure 2, indicating 5% rate of tax. Annexure 3, indicating 12% rate of tax. Annexure 4, indicating 18%. And Annexure 5, indicating 28%. Now, these annexures, as they were listed in the agenda, I'm just scrolling them down as to how they were recommended. Just to have a glimpse for you, you can yourself download it from the website of the GST Council, the agenda for the 14th GST Council, and minute also of the 14th GST Council, because this is the most crucial missing. We decided the rate of tax with respect to various items. Now, in these meetings, now this agenda was discussed in the 14th GST Council meeting, and the GST rate schedule recommended by the Fitment Committee was approved on the meeting held on 18th and 19th of May. And all these 5 annexures covering about 1211 items were approved. And out of these, and it was decided that the GST rate will be generally prescribed at 4-digit classification. So it was very specifically stated that unless a carve out is essential at 6 or 8-digit level, if an item is described in a particular manner at the 4-digit level, then that 4-digit level description will be applicable for all the sub classification also. So for 8-digit and 6-digit, unless a specific mention is made in the schedule to the notification, whatever rate is prescribed at the 4-digit level, that will apply to all the items at the 6 and 8-digit also of that 4-digit classification. So it was the objective was to have a much simpler classification regime, wherein the objective was to classify at 4-digit level only, because if at 6 and 8-digit level, if the classification is done, then it is possible that if an item is not described in a particular manner as described at the 6 or 8-digit level, then it will lead to classification dispute. That is my understanding. Because till now, the central excise and the customs tariff described item at the 6 and 8-digit level. And if there is a difference in the rate of tax, then there is always a possibility that there will be some litigation between the department and the SAC with respect to under which sub-classification my item falls. And if it is a 4-digit level, then it is much easier to understand where your product lies and to determine the classification of your item. So this was done only at the 4-digit level, wherein only 1211 items were notified. And it was presumed that whatever is not notified is covered at that 4-digit level notification. But unfortunately, in the rate notification, there is this entry 453, which says that if an item is not classified elsewhere, then it will go to residual category. So which means about 88 to 89% of the items now will go to the residual category because they are not specifically notified. Now, in my view, it is absolutely arbitrary and unreasonable to presume that the government, which gave a mandate to the fitment committee to find out the rate of tax, chose to leave 89% of the item non-notified. And they were supposed to go into the residual category. It cannot be the intent of the government to not notify 89% of the items just because they are not finding a specific mention in the rate notification. Because if you look into the customs tariff, at the 6-digit and 8-digit level, then the number of items comes to about 11,000. And against those 11,000, only 1,211 items were notified. So the interpretation that 89% of the item goes to the residual category is absolutely absurd and unreasonable. Secondly, the most important point is that you will be shocked to know that this residual category does not find a place in the annexure to the agenda of the 14th GST Council meeting, meaning thereby that this residuary category entry or residuary entry number 453 never existed in the schedule 3, and I will show you as to how the agenda items were there with respect to 18%, the last item. If at all this was there, then it will be the last item in the 18% category. I'll just show you a few last pages of the schedule list of goods which were supposed to be, which were in fact recommended by the fitment committee to the 14th GST Council meeting just now. So as you can see, chapter number 95, electronic toys, 96, miscellaneous manufactured articles, 98, project imports. And as you can see, there is no residual entry. If I scroll down further up also, I don't see the residual entry. So as you can all see, the residual entry was not at all recommended by the GST Council in its 14th GST Council meeting, wherein the rate of tax with respect to various goods and services were discussed in detail on recommendation of the fitment committee. A detailed agenda, including all the items which were to be notified, was discussed in the 14th GST Council meeting, and there was no trace of the residual entry in that agenda. So if the residual entry has never been discussed in the GST Council meeting, then it is contrary to Section 9 of the GST Act, which says that the rate of tax can be notified only on the recommendation of the GST Council. So since this particular entry has never been discussed, never been decided. So in my view, this residual entry is totally unconstitutional. And furthermore, to presume that 89% of the items GST Council left undecided and to be included in the residual entry is also unreasonable, arbitrary, and contrary to the general principle of classification, or that is the HSN classification, which was adopted by for the purpose of the GST. And therefore, in my view, this particular residual entry is invalid and contrary to law. Now, a lot of litigations are going to arise under this particular or around this particular entry only, because what the officers are doing, if the description, as it is mentioned in the tax invoices, is not matching with the description as has been notified in the rate notification, which was issued on 28th of June 2017 and which has been notified or amended from time to time, then they say that look, your item is not covered within any of the description or the item which has been notified. And since it is not covered within the, since it is not matching with the description in the rate notification, so it will obviously go to the residual category. And if you are availing the beneficial rate of say either 5% or 12%, then they are trying their best to classify it under the residuary entry number 453 of the rate notification. So I believe that a lot of litigation not only is undergoing, but a Pandora's box is going to open in the near future, where the officers will, in order to augment the revenue of the government, will try to bring the items which are covered in 5% or 12% on the slightest pretext, on any, if they get any window of opportunity wherein your item description, the way you describe it in your tax invoices, does not match with how it is mentioned in the rate notification in Schedule 1 or Schedule 2 of the rate notification, then they will endeavor to bring it in the residual category. And as I have discussed, the only option to challenge such a classification is to challenge this rate notification, this particular entry itself, before a high court by virtue of writ petition. One such litigation is already going on before the Honorable Madras High Court, which we filed last month. And we have also got an stay on the demand by virtue of this taking recourse to the residual entry. With this, I conclude my today's session. Thank you very much. I will continue to discuss various facets and aspects of the classification of the goods and services, because I believe that a lot of litigation is going to be initiated by the government with respect to the classification issues. And in my forthcoming session, I will discuss with you the certain tips to deal with the classification disputes. Thank you very much.